to this licensing subcommittee for Friday, the 9th of October, via Zoom. The first item is attendances. So what I think we'll do is some introductions. I'm Councillor David Jarman. I'm chairing the committee. So if we can ask the other two committee members to introduce themselves first.
I'm Councillor Barry Brotherton.
And I'm Councillor Dylan Butt. I'm the member of this committee. Thank you.
Can I ask the legal officer, licensing officer, and the clerk to introduce themselves, please?
Yeah, my name's Joanne Boyle. I'm the licensing team leader.
I'm Sage Lenahan, solicitor from Trafford Council.
Natalie Owen, Democratic Services Officer.
Okay, and we have people attending for, well, the only item really that we're considering today, which is the application for the grant of a premises licence for Common Ground, 20 Shores Road, Altrincham. Now, do we have a Ms. Tullock, the applicant?
Yes, afternoon, Chair.
Good afternoon. And do you have a Mr. Besbrode?
Yeah, good afternoon.
Oh, good afternoon. And Nasreen Ali from our Environmental Health.
Yes, good afternoon, Chair,
Good
and
afternoon.
everybody else.
Hello, Nasreen. Right, so just to run through the order of procedure, what I'll do is ask the licensing officer to outline the application. Then I'll ask the applicant or the applicant's representative to outline the application from their point of view, and then after that there'll be questioned by the panel officers and the representative. After that, the representative, the environmental health officer, will put her case, and then after that she can be questioned by the applicant, the committee, the officers, and the applicant in that order. So then I will ask all parties to summarise, starting with the representative and then the applicant, and then there will be a briefing by the legal officer before we'll go into a private session to determine the outcome. So is that everybody clear about that? Are there any questions? Okay, can I ask Joanne Boyle, please, to outline the application?
Thank you, Chair, members of the subcommittee. The Licensing Act 2003 provides that a premises licence is required in respect of any premises where it is intended to conduct one or more of the four licensable activities, these being the sale of alcohol, the supply of alcohol in respect of a members club, regulated entertainment, and or the provision of late night refreshment. An application for a premises licence has been submitted to the authority by Kite Solicitors on behalf of the applicant Common Ground Coffee Limited in respect of premises at 20 Shores Road in Altrincham. The premises are currently not licensed and are described as a coffee shop and bar trading on the ground, first and second floors. The licensable activity applied for are films, live music and recorded music indoors, supply of alcohol both on and off the premises, and late night refreshment indoors. The days and hours applied for are detailed in the report. In terms of the application process, the licensing section is satisfied that the application has been made properly and all the procedures followed, including the advertising and notification of the application. A copy of the application and location plans are attached to the report at Appendix A, and a photograph of the blue notice and a copy of the newspaper advert are attached at Appendix B. The applicant has completed an operating schedule as part of the application, which outlines what measures would be in place to promote the full licensing objectives and which would become conditions on the licence if granted. Those measures are listed in the report at section 3. During the consultation, the authority received one representation. The representation is from Ms. Nasreen Ali from the Council's pollution team, who has objected to the application in respect of the use of the first and second floors of the premises on the grounds of public nuisance. Ms Ellie does not object to the application in respect of the ground floor, provided the measures proposed in the operating schedule are applied, together with the additional conditions which she has suggested in her representation. A copy of Ms Alley's full representation is attached to the committee report at Appendix C. Finally, the subcommittee should note that the premises are situated in Altrincham Town Centre, which is an area identified in the Council's special saturation policy as a cumulative impact zone. Cumulative impact means that there is a potential impact on the promotion of the licensing objectives of having a significant number of licensed premises concentrated in one area. The effect of adopting a special saturation policy is to create a rebuttal presumption that applications for new premises licenses in the areas identified be refused, if, that is, relevant representations to the effect are received, and unless it can be demonstrated that the operation of the premises will not add to the cumulative impact already being experienced. Applicants should therefore address the special policy issues in their operating schedules in order to rebut such a presumption. The fact that the authority has a special saturation policy doesn't mean, however, that applications are automatically refused. The policy does allow for each application to be considered on its own merits, and the applications that are unlikely to add to the cumulative impact can be granted. The representation from the pollution team doesn't refer to the saturation policy. However, the premises does lie within that zone, and the subcommittee should consider if the operation of these particular premises would add to the cumulative impact in the area. In order to determine that, the subcommittee should consider such factors as the occupancy of the premises, the proximity of the premises to other similar premises in the area, how the premises will be managed by reference to the operating schedule, the hours of operation, and the transport provision, and if there's any dispersal policy proposed by the applicant. In closing, I'd invite the subcommittee to consider the report, the written and verbal submissions of the applicant and Ms Alley, and having regard to national guidance and the Council's own licensing policy, take such steps as it considers necessary for the promotion of the licensing objectives. And that's all I propose to say at this time, Chair, unless the members have any questions for me.
Does anybody have any questions for the licensing officer?
Not a question, sorry, my voice. Not a question as such, Chair, but the premises on the ground floor does already benefit from a premises licence. I think, Ms Boyle, you mentioned that it wasn't currently licensed. It is, it's been licensed for a number of years.
Apologies.
But obviously the application is for a new licence because we're increasing those hours and going into the upper levels. So a new licence was felt preferable rather than a variation to the existing one. Thank you.
Okay, got that, thank you. Right, then, Ms Tullett, will you be representing the applicant then? Would you like to carry on with your submission, please?
Yes, thank you very much, Chair. I don't propose to talk much more about the terms of the application because Joanne has set out exactly what it is that has been applied for. Damien has owned the premises for a couple of years, but it has been licensed for longer than that. The application seeks to go into the first and second floors, part of the building which Damien already owns, to enable him to provide licensable activities up there as well. We believe that if you were to grant the licensing objectives would not be undermined for a number of reasons. Firstly, as Joanne mentioned, we submitted an operating schedule with the application, which in our view was robust and thorough and goes beyond those conditions which are currently attached to the existing licence. And if I can draw your attention in particular to two conditions which we've offered, which I think go to the heart of the concerns which Nasreen has, and that is the escape of noise from the first and second floors and the potential that the use of those floors might have to disturb those who might live nearby. and those are found in your papers at 3.16 and 3.17 of the operating schedule. 3.16 says that noise from amplified music or voices shall not be such as to cause a nuisance to occupants of nearby premises. And 3.17 says no noise shall emanate from the premises, nor vibration be transmitted through the structure of the premises, which gives rise to a nuisance. And Nasreen, in her representation, asked us to consider accepting a number of other conditions, which Damien is more than happy to do so, and that has already been communicated to Nasreen. And within those conditions, I would want to draw your attention in particular to PPN3, which reads, noise from music and associated sources must not be audible to such an extent that it constitutes a nuisance at any noise-sensitive premises. And it would be our submission that those conditions, combined with the others, both offered by us and agreed following Nasreen's objection, form a robust set which guarantees that a nuisance won't be caused to anyone living in the vicinity. You'll have seen in the papers that there has been discussions regarding the occupancy of a flat nearby to the premises. There is a flat above Sugo Italian restaurant at first floor level, which is adjacent to the first floor of common ground. The resident there is Amy Williams, and you should have before you an email from her that was submitted earlier this week, in which she explains that she's happy with the terms of the application. She has no objections to it and wishes for it to be granted and not refused on her account. I think there was some confusion about whether there were any other residents near to Amy. She is at apartment 3, but there has been reference to apartments 1 and 2 during the course of discussions, but I think it's been confirmed by an email submitted by Nasreen this week from the landlord that there are in fact no other occupants above Sugo. There appears to be plans to develop them, but at the moment there's only one occupied by Amy, and she's happy with the application. And I think I would say that we can't speculate at this time as to whether future residents of flats which have yet to be developed may or may not be disturbed or may not object to an application or a licence such as this. I think what we would say is that the conditions that have been offered will ensure that regardless of whatever licensable activities take place on those floors, noise will not escape and disturbance will not arise as a result. Since the consultation period ended, Damien and I have been in contact with Nasreen to discuss her concerns. We've spoken, we've emailed, we've suggested and offered a meeting on site to try and resolve matters, but unfortunately we've not been able to do so. But we have narrowed the issues somewhat. As I've said, we've agreed to the various conditions that she requested. I'm more than happy to do so. We've also offered to reduce the hours that we have applied for. You'll see in the papers before you that the hours sought were until midnight during the week and 1 o'clock at weekends. We communicated at the end of September to Nasreen that we would no longer be seeking a 1 o'clock terminal hour at the weekends. And so if you were minded to grant the application today, we would ask that it was granted until midnight daily for licensable activities, with an additional 30 minutes thereafter to allow for dispersal. And that in our view would give or would result in a relatively standard licence for the area. The common ground is opposite the market, right in the centre of Altrincham, next to Sugo, which has a licence until 11, the cellar with a licence until midnight during the week and 2 AM at weekends, and a couple of doors down from Pye, which has a licence until 2 AM daily. And a licence was granted earlier this year from an application which I submitted on behalf of another operator until midnight daily, opposite on the former Nobles Amusement Arcade site. Reference has obviously been made to the existence of the cumulative impact policy that is in force for Altrincham. Conscious that I've not addressed that yet. But as Miss Boyle pointed out, it's not been referenced in Nasreen's objection. She's not asking for the application to be refused. As you've heard, she has no issues with the operation of the premises on the ground floor. It's the issue of the use of the first and second. There have been, as you'll be aware, no objections from the police, none from any other licensing authorities, any other responsible authorities, and none from any residents at all. We've had regard to it when formulating the application, and it was done so in light of it. But I think I would say that licenses have been granted regularly whilst the policy has been in force, and successfully. Indeed, the common ground licence, the original first common ground licence, was granted, notwithstanding the existence of that policy. So whilst, of course, you must have regard to it, I would ask that you grant the licence in spite of its existence. This application is made against a rather unusual backdrop. The hospitality sector over the last 6 months or so has faced huge hurdles and difficulties, a long period of lockdown followed by a brief respite, but now what appears to be an imminent further closure for a period of time, certainly in the north, from perhaps as early as next week. Altrincham, though, has thrived during that period of reopening, perhaps more so than areas such as city centres. More people are working from home, going out more locally, and rather than journeying into city centres, more are staying local. And I think we would ask you and urge you to grant the licence to enable the town centre to continue to thrive. It is now, after years of underuse, a very successful and award-winning town centre. I moved here a couple of years ago because of what it offers, and the role that cafes, restaurants, bars play in the regeneration of the area, I don't think can be underestimated. And so I would ask, as I've said, for you to grant it. And I think in summary, I would say that the only person who could be reasonably expected to be impacted by the application is Amy Williams, the nearest neighbour, but she doesn't want you to refuse it, she wants you to grant it. And there are the safeguards, as I've said, in place, that if you were to do so, there's no risk to the licensing objectives or to her amenity if the licence were to be in place. So unless you have any questions of myself or Damien, then that's the application in summary. Thank you.
Thank you, Ms. Toller. Can I just ask you, we've had sight of an email via Nasreen Ali from the landlord of the property next door, because he's obviously looking to market those apartments shortly, and he doesn't know who he's going to get there. Obviously, he wants to attract the widest scope possible of customer. Now, they might not be so keen as Mr. Williams, obviously, to live next door to something where the noise and vibration are coming through the walls. So I just wondered how you could guarantee that wouldn't actually happen.
Yes, so the three conditions, the two which we offered and the third which we've agreed at Nasreen's request, will create legally binding requirement on Damien not to cause any issues, whether that's by noise breakout, vibration, or any associated issues, and enforcement action can be taken against any breach of those conditions. The landlord is Amy Williams is landlord, and At the moment, the other flats aren't there. They've not yet been developed. And whilst we may speculate on what might happen in the future, at the moment, the only resident next door is Miss Williams.
Okay. Can I just ask, does the premises at this stage have planning permission for the first and second floor operating as a cafe bar?
Yeah, Damien's nodding. I'm not a planning expert, but Damien has. I don't know if you can confirm to the committee, Damien.
Yeah, it's within the lease that's granted for it that it's allowed to do it.
As a coffee bar, right.
As a
Okay.
licensed coffee bar,
The
which is
license-
owned by the council.
Right, okay, thank you.
Can I just add to that? I spoke to colleagues in the planning enforcement team with regard to the planning status of the premises, and they basically said that the premises was previously split into two, with the ground floor occupied by a cafe and the first floor as a barber's shop. I think the barbers closed in 2017. And basically the cafe expanded to include the upstairs. So both uses now fall within use class E. Therefore, a change of use between the uses, it does not require planning permission. So the actual premises are permitted for that use at first and second floor.
Okay.
Sorry, Chair, can I just add, although we're talking about planning, I just want to make it clear that planning isn't a relevant consideration for this committee. It's a separate legal process which planning would need to consider separately.
And that's just obviously a matter of interest. Yeah, okay. Can I just ask the other members of the committee if they have a question they'd like to ask the applicant?
Thank you, Chair. I'll take it if it's okay. What I just wanted to ask was, what type of music do you intend to be playing there at this venue?
Damien may be able to give you a little bit more detail in a minute. The application is for live and recorded music. We've applied for it in its amended terms until midnight. I think it might be worth mentioning at this stage, obviously, that the Live Music Act provisions would apply in any event if the licence were granted, in that live and recorded music could be played up there until 11 p.m. anyway. So we're simply seeking an additional hour above and beyond that. Damien will be able to explain more about the size of the first and second floors, and that they are modest in size, and the music would give them the flexibility. The provision for music will give them flexibility to allow for a DJ or a small band or an acoustic musician to play up there. But Damien, I don't know if you want to elaborate.
Yeah, thank you. I think you've covered it. So, you know, it's for a combination of either just background music, as we currently have the ability to do with a coffee shop during the daytime, or as Felicity said, to have acoustic music or live poetry or small bands or a DJ. So it's a combination of any of those to provide, you know, background entertainment to people who would be coming to eat and drink.
Yeah, because I know that being the sort of,
go on, sorry.
I'm saying it's being the sort of area it is, and the kind of people that probably be sort of there for entertainment wouldn't be looking at sort of heavy metal or rock or any kind of loud kind of music. So yeah,
it would be you know, the sort of thing we're talking about is probably like, you know, acoustic guitar, you know, that sort of thing. The clientele that we currently attract and would be aiming to attract in the evenings would be the sort of people that would be wanting to talk and have some background music. You know, it only seats approximately 30 people on the first floor. Obviously with COVID spacing, that's reduced. And on the second floor, pre-COVID, it only seats 8 people, which is now down to 4. So you're not talking about a ginormous space with a massive dance floor. It's got existing tables and chairs for people to sit down and eat and drink out.
yeah. Okay, thanks.
Sorry, just to clarify that, so the live music would take place on the ground floor, and there would be a PA system on the first and second floor, is that correct?
No, it would be more likely to be based on the first floor.
On the first floor,
Yeah.
right. Will you have a PA system on each floor?
We currently have Sonos that goes through the building. It's not our intention at this point to be piping the music on both, all the way through. It isn't a ginormous building and it is quite open planned. So if there was a singer on the first floor, you would hear them on the ground floor anyway. But the ground floor is where the main bar and entrance is. So it wouldn't make any sense to have live music on the ground floor because of, people are ordering. Obviously at the moment with COVID, you can't go to the bar and order anyway. But yeah, no, it would be on the first floor.
The first floor, right. Okay, so what happens on the second floor? Is there any music up there?
Well, again, it's the background music. You would hear the music. It's not a big place. So if there was a band or a singer on the first floor, you would hear them in the second floor. It's literally open plan up. Or equally, it would be a quiet space for people who didn't want to listen to the singer to sit and have a quieter drink. More like a snug.
All right, thank you. Can I ask Councillor Brotherton if he has any questions?
Yeah, can I just ask about the flats next door? I understand one's occupied by this lady. Are the other flats there but unoccupied, or are they in a state of disrepair? Do we know what are the other flats? Are they imaginary or are they actually physically just have no?
Amy is advised from speaking to her, and obviously I know Nazreen will comment in a second, that there is no front door up there apart from her own. So to our current understanding is that they aren't yet developed and that they will be developed. Whether they are existing with no door or in a state of disrepair, we don't personally know. But Amy is advised that since she's been a resident, nobody else has entered the building and the post that comes to those flats is uncollected apart from when the landlord comes. So there is only one access point, which is currently to her flat.
I'd just like to add to that. In making my sort of assessment of this application, I've had to review the planning history relating to the site. So planning permission has been granted for some time for residential apartments at 22 to 26A Shores Road. So Amy actually lives at number 26, so she lives above Sugo, but not the Sugo that's adjacent to Common Ground. She lives, so there's Sugo Kitchen, there's a barber's shop in the middle, and then there's another Sugo restaurant, I think, and then there's Common Ground. Amy actually lives the furthest away from Common Ground, and the two other apartments in between, so at number 22 and 24, my understanding is that access arrangements and so on have been put in place, and the premises are in the process of being refurbished. So when I've reviewed the application, it's based upon what's permitted there. So yeah, so that there is actually permission for the apartments, although somebody's not living there, and maybe they're being refurbished. But the owner of the property has clearly indicated that they're going to have some tenants in it, and once the necessary arrangements are in place.
Just to add on that, Nazreen, when I spoke to Thornley Groves, who let the flat that Amy lives in, and who acted for the landlord, they had, obviously there are multiple letting agents, they had no knowledge of the other flats being coming to the market at any time in the future. Right,
okay. I can't comment on that, but there's clearly residential property on the other side of the application premises, and it's important to note that Amy actually lives 2 doors away from your premises as opposed to directly adjacent to your property. And even if she did live adjacent to your property, my concerns are still in existence, really. But just to confirm to Councillor Brotherton, the 2 premises, the 2 other apartments are definitely going to be residential as indicated by the applicant. Earlier on this year, the applicant actually did submit a planning application for some modifications to the layout of the apartment. So my understanding is that they were refused on conservation grounds, but they're actually in the process of going back to the planning section to update their plans and address the concerns. So it's not just like a dormant premises that's there with no intention of any development. The fact that the applicants submitted planning applications a few months ago clearly indicates that you know, he's serious about the prospect of having residents in there. So you've got residents very close to the application premises. And if you look at the actual plans, the permitted plans, as it stands now, you have 2 bedrooms and a lounge on the other side of the party wall of the application premises. And that's really where my concerns stand. You've potentially got live music, recorded music, performance of films, etc., up until 12 o'clock in the morning, every night of the every night. So you could have a young professional sort of living there. I understand the concept of sort of people in Amy's representation. She's talked about in her email, she's talked about the fact that she lives in the town centre, and you know, I appreciate that. That's her choice to live there. But residents who live adjacent to this particular premises will be disturbed by noise from the activities, so they won't have a choice to sort of like walk away from that. They'll be sat in their bedrooms or living rooms, etc., being negatively affected by noise from the activities, live music, recorded music, etc. Yeah.
Okay, can I just ask about the occupancy rates? Ask the applicant about the occupancy rates in normal circumstances, i.e. non-COVID circumstances. What would be the occupancy rates of the 3 floors?
So pre-COVID, the top floor can seat 8 people, the middle floor seats 32 people, and the ground floor seats approximately 22 people. And then you've got the outside space at the front and the rear.
Okay, and what about standing? What's the maximum you can take in the whole premises?
The maximum on the ground floor is 70, and on the first floor is 50.
Okay, thank you very much.
Not that you would, just to finish on that, you would never have that, because it would not be a pleasant environment. You know, it isn't a nightclub environment. It's a, you know, upmarket coffee shop, an evening place. So that wouldn't actually ever be something that would be realistic, and especially in COVID times, it's not going to happen anytime in the foreseeable future.
No, it's not going to happen anytime soon, certainly. Has anybody got any more questions of the applicant? In which case, can I move on to the representatives, which I think is just you, Nazreen, if you want to say your piece about the objection you've raised.
Yeah, that's fine. Thank you. Thank you, Chair. So basically, I received the variation application and reviewed the proposals. The application wanted to, the applicant wanted to have live music, recorded music, late night refreshment, etc., up until 1 o'clock Thursday to Saturday, and midnight Sunday to Wednesday, although I understand this has been changed now. When reviewing the application, I looked at the plans for the ground floor, first floor, second floor, maximum of, I think, 32 covers on the first and 10 on the second floor. I didn't have any objections to the proposal on the ground floor, because it's really in line with other licensed premises in the area, Shaw's Road, Greenwood Street, etc. But I did object to the application for regulated entertainment on the first and second floors on the grounds of public nuisance. And the reasons really for the representation were the fact that you've got noise sensitive premises adjacent to the application premises on the upper floors. So as I said earlier, you've got 2 bedrooms and a lounge on the other side of the party wall. So noise from live music, recorded music and playing of films up until midnight, potentially 1 o'clock during the week would be an issue to the residents of this apartment. in addition to noise from the regulated entertainment, noise from other activities, for example, customers, restaurant type noises up until 12:30, 1:30 in the morning, from up to 20 to 50 people could be, you know, problematical. Even if the live music, recorded music element was not there, if you can imagine a room full of 20 to 50 people enjoying themselves, not unreasonably really, on an evening, you know, it's going to be inevitable. So having reviewed the sort of locality, this particular licensed premises, it's at a disadvantage because it's structurally attached to this residential property. And with entertainment noise, especially when it's at lower frequencies, it can be readily transmitted through the structure of a building and be clearly audible within habitable rooms of the dwellings. So in my opinion, the proposal to extend the hours on the first and second floor is really something that is going to have a negative impact on the residents. The noise would be clearly audible within the residential premises. And when I've looked at the application, I'm also looking at the provision, the license, the provision for the premises to be fully utilised. So serious nuisance impacts could arise for residents who are relaxing in the evening and even sleeping, you know, at night time up until 12:30, past midnight. In my opinion, this would be completely unacceptable to residents who would be able to hear the noise, and there's no sort of, the events could be unrestricted. There's no, obviously with the COVID situation, you know, there's a limit on numbers and so on, but the license would allow for this type of entertainment activity to go on until the early hours of the morning. Just, I know we're not supposed to talk about the planning situation, but in the absence of a planning control, it's important that you know, consideration is given to the fact that normally what happens in sort of Altrincham town centre, for example, we meticulously review planning applications to ensure that the residential stroke commercial uses are in sync with each other. So over the last few years, Altrincham Town Centre has seen an increase in a number of residential applications. So from a planning side of things, we would look at, I review applications to make sure that there's proper measures in place to ensure that the residential premises are not impacted by commercial. We'd even recommend refusal for certain residential applications if they're next to licensed premises. We recommend mitigation measures, glazing, etc., to protect the residents. So it's really important for you know, the residents of these apartments. So there's a permission for residents to be at these apartments, and they really need to be protected from live music, recorded music, entertainment noise at the neighbouring premises. So my recommendation really is that the licensing committee refuses the application. Just want to add about the town centre location. I accept that people live in town centres knowing that they're going to be busier than other areas, but what I do not accept is that they should be exposed to entertainment noise on the other side of a party wall up until potentially 12:30, 1 o'clock in the morning. I think that's very important. So my opinion is that the members, committee members, have a duty to ensure that the noise sensitive residents are not exposed to public nuisance, exposing residents to public nuisance. We've had a number of scenarios across the borough where similar situations exist. You've got sort of licensed premises next to residential, and various conditions have been imposed to sort of mitigate the noise, but you know, circumstances like this, in my opinion, really, it's a case of not allowing that use to be there in the first place, because even if you've got 10, 15 people on the other side of a party wall, having a good time, irrespective of music, live music, recorded music, there is the potential for noise to have a negative impact, you know, on the residents. I also made mention to the fact that I've had email communications with the owner of the residential apartments next door, who's obviously concerned about the impact the live music, regulated entertainment will have on any potential tenants. Tenants are transient in nature, but obviously as an owner, it's an important consideration really, to ensure that, you know, the apartments are, the occupants of the apartments are not negatively affected. That's basically it really. There's not a number of residential licensed premises in the area, and the majority of them are on the ground floor and they have relevant conditions. This is different to other licensed premises in that you know, they want to have activities on the first and second floor adjacent to sensitive premises. So that's really the key concern. I accept it's Altrincham town centre, busy area, etc., but it's also a residential area, and there is a history of complaints relating to other licensed premises in the area. So you've got residents complaining about noise from them. So it's really about striking that balance more than anything else.
Okay, thank you, Miss Ali. Can I just ask you then? So, despite the recommendation of the conditions that you've made in your submission, what you're saying is quite clearly that still isn't enough to take noise to the second and third floor.
In my opinion, no, and based upon experience in the borough, we've had cases where, for example, if I was looking at this from a planning application perspective, I would be requiring, you know, detailed information. I probably would recommend an objection for permission, because you've got a residential use adjacent to a licensed premises. So that would be my view. We have to look at protection of residential amenity from a planning side of things, and obviously from a licensing side of things, we're looking at the prevention of public nuisance. So my personal opinion, and based upon experience that myself and colleagues have had across the borough, is that despite the imposition of conditions, you know, you have you know, noise complaints relating to premises. You've got 2 bedrooms and a living room on the other side of a party wall, and you're going to have live music, regulated entertainment, music from up to 32 people sat down having, you know, having a nice time, which they're rightly, you know, doing so, but it is going to have a negative impact. And a resident who lives in the area, who chooses to live in the area, has the choice to walk away from the noise, or they're in control basically, whereas a resident who's actually sort of, if living adjacent to this property, they're going to be negatively affected by noise, entertainment noise taking place next door up until 12:30, 1 o'clock in the morning. Like I said before, Amy lives a few doors down, but you could have a young professional couple living next door, sort of working all day, coming home, maybe going to the bars and so on, coming home at 11, 10, going to sort of retire for the day, and then next door you've got entertainment noise up until 12:30, 1 o'clock in the morning, which is, it's not appropriate really.
But I just clarifying, if you know, I mean, I was under the impression that all these properties, 22 to 26A, is it, are in the block next door. Is that correct?
They're in what, sorry?
In the block next door to the premises, the common ground premises, or are they spread out? I was under the impression.
No, they're next door. So basically, sorry to interrupt you. So there's common ground, which is number 20, and then you have number 22, which is Sugo Kitchen, I think. Then you've got number 24, which is a barber's shop. And then on the other side of 24 is 26, which is another Sugo, but that's like a Sugo, I think a takeaway type premises. So directly above each of those three premises is a flat. And
right, so they're all separate properties. They're not all just one block of flats with different numbers then. But they're all separate properties, aren't they?
Yes,
Yeah.
so the shops on the ground floor are separate, and the flats above again are 22 to 26A. They're owned by the same person, and my understanding is they're basically split into three separate flats.
I've got it. Thank you, Miss Ali. Does any of the other committee members have any questions for the Environmental Health Officer?
Yeah, can I come in on that? Yeah, Chair.
Yes, Councillor Butt.
Yeah. In terms of residential properties, how many are there in that particular square surrounding the market?
Surrounding the market? Now,
yeah.
I'm aware that recently over the last few years there's been quite a lot of sort of change in the area. So I am definitely aware that from 22 to 26 there's 3 residential apartments there. There's some on Greenwood Street. There are some on Market Square, I think, Market Street. Just let me have a look at my record, because we've had some complaints from residents that so there's sort of dotted around it above various residential premises. I think
as far as I know, the offices, the solicitors and people like that along Greenwood Street. We're talking particularly around that square area.
Right, so you've got the premises, the residents above, next door basically, so above Sugo, the hairdressers, and
so you're only talking about those 3 then?
Yes, and there is somebody to the rear as well. Felicity mentioned in her comments that there's a resident who lives to the rear of the site as well.
Has there been any objection from that resident?
No, Councillor Butt, if I may, Damien has been speaking with him. He's a gentleman called Sam, and he has no objections to the application whatsoever.
Another point is, why hasn't the property owner, the shop owner, the objector, not present on this meeting?
My
Why are you
understanding
doing the sole
is,
representation?
my understanding is that he wasn't aware of the application. So I've obviously, when I've looked into this application, as I do with every other single application, I've reviewed the planning history and licensing history, etc. Basically,
It wouldn't be. The thing is if he's a businessman in the area, yeah, and he owns properties there, I'm sure he's not. He's familiar with how applications are considered and done, and he would be aware of what's going on.
Yeah, I mean, I can't comment on that. All I can say is that, for example, if it was a planning application, nearest residents are notified by the planning authority of the application, whereas with licensing applications, it's a case of notices at the application premises, I think, and something in the local press. So I'm not sure, I can't comment on that.
Right. In terms of those flats, you're
Yes.
saying that,
Yeah.
have they ever been inhabited? What have they been used? What's the history behind them?
My understanding is this permission for residential was from commercial. I think they might have been offices in the past, but they have been these two, the adjacent premises. I don't think has been occupied, but there are plans, as I said earlier.
Yeah, the thing is, there were offices before.
Yes.
Right. Would you not think that people that were wanting to say, like you mentioned, for example, a couple that might be working late, would it make any sense for them to buy a flat in the middle of a market area, which is essentially developed as a nighttime economy? All the businesses around there are restaurants, bars, and specifically in that market areas, which is quite enclosed,
yeah,
is what's created Altrincham the way it is, yeah, and it's developed. So it does not make any sense to have residential property in that particular focus area.
Yeah.
You know, if anybody wants to live there, by all means, they can live there. But as I think you mentioned about the resident Amy was saying that he doesn't mind, and aware of the fact that people come and, I mean, who would want to live right in the heart of a market which is effectively a nighttime economy?
Yeah, I understand.
Who's going to be worried about noise and, you know, disturbance and things like that? Can you explain that?
Well, this residential permission has existed, I understand, prior to certain sort of activities. You know, so for example, I'm not sure how long other licensed premises have been there, but my understanding is that this residential permission has existed for some time.
How long ago?
I can't categorically say exactly when, but it has been some years, definitely 2012 maybe, I think. I'd have to have a look. I can't comment on the date that the permission was granted. But
would you not think that the businesses that there at the moment, existing businesses, would probably have some kind of say instead of something that's not even potentially ready or prepared in any way? So for, you know, to be looking at it's, you know, for example, somebody wants to go live next door to an airport and then complain about the noise.
Yeah. I understand that. I mean, I'm looking at the application. I'm looking at a noise sensitive receptor that's there, and the neighbouring licensed premises who want to expand onto the first and second floor. Other premises, licensed premises in the area, I've got a list in front of me. They all have forms of regulated entertainment on the ground floor. So you've got Pi, who's at number 18, Sugo at number 22, The Cellar. There's numerous restaurants up and down Greenwood Street. There's Blanchflower. There's the one that Felicity recommended earlier. I'm not against the nighttime economy in Altrincham. I encourage, especially in this day and age with COVID and the way things are going, really. I'm not against that, but it's my duty to protect the noise sensitive occupants of a residential property that would be impacted by, you know, thorough, you know, noise.
It does seem to be strange. Just to finally, it does seem a bit strange that, you know, if you were sensitive to noise, the last thing you'd be wanting to do is go and pitch yourself right in the middle of a nighttime economy, an entertainment venue, effectively, you know. And it's a very enclosed pocket, you know, so that square. If you were on the high street, that would be different, you know. It's spread out or somewhere else, but you know, the let's say uniqueness of the market area is not reflected in other areas, where you might get residential people.
Point totally noticed, but what I have to point out is that you've got numerous entertainment venues, licensed premises that have conditions which control noise from those licensed premises with it. So the noise is actually contained within the premises, and also there's restrictions, there's conditions restricting noise in the external areas up until I think 2300 at the latest. So there are controls. We've got a mixed area. We've got to sort of highlight that we have a mixed area. There's apartments sort of on near to the town hall, overlooking that area as well. So we don't have a strictly sort of commercial area. It is a mixed area.
Which apartments are you talking about overlooking the town hall?
There's some apartments, Market Square or Market Street, overlooking the sort of to the rear and side of the town hall. We've had some complaints from there. But just going back to the point again of this actual residence, my issue is about somebody who's living next door to an entertainment venue and being impacted by the noise. I know people choose to live in Altrincham town centre and they understand the noise and the impacts, and there are controls on licensed premises, but here we've got a residential premises which was there, you know, it's permitted for a number of years, and the neighbouring licensed property wants to have licensed activities up until the early hours of the morning.
Councillor Butt, can I just...
Okay, that's it. That's fine.
Sorry,
But
I'm just going to say that you might not be aware that Sugo itself is licensed, and we're talking about the flat above Sugo. Sugo itself is licensed, and I've employed the chef that used to work there, the head chef, and they play music when they're serving the food and at the end of service. So I do understand your concerns, Nazreen, but regardless of whatever happens with us, the noise for that flat above is not going to, you know, it's going to get noise directly above Sugo, which is a bustling restaurant that's open till 11. It's licensed, I think, till 11 o'clock, and then plays music while they clean down. So to think that there's going to be no noise going through the ceiling and affecting this flat, regardless of what happens with my application, is...
Can I just go back to your original question, Chair, just to get straight in my own mind? Is the only flat which has got a common party wall with the applicant number 22, and number 24 and 26 are further down the street? Is that correct?
Yeah.
Yes.
Yeah. And then is there another flat at the back of this premises that has a common party wall?
One flat.
There's just the one flat that has a common party wall.
That's number 22.
Number 22, yes.
Yeah, thanks. Somebody mentioned a flat being at the back. I couldn't visualise where that was.
Councillor Brotherton, it's overlooking, there are flats along Greenwood Street.
Yes.
Some of those back over the backyard of common ground. And
yeah, but no common party wall, just the backyard. Yeah.
Just going back to Damien's point about Sugo, I understand what he's saying about Sugo. Sugo has a license, but there's controls on that license, and basically they're not allowed to be open beyond 11 p.m. So at 11 p.m, it's total silence at Sugo. But what you're proposing is going to be noisy up until potentially 1 o'clock in the morning. Or
not 1 o'clock, Nazreen.
No, half past 12.
It's 12. It's 12.
Well, the premises will be open till 12:30. So you potentially got noise on the premises on the first floor up until 12:30 a.m. every day, every night of the week.
Can I just ask you, you refer to other complaints, obviously not relating to this premises. What do you mean by other complaints, and what about?
We've had complaints of specifically in relation to Altrincham. So there's other licensed premises in the area. One thing is very important to note is Altrincham town centre and this market area is not strictly just licensed premises. It is a mixed area. There are residential premises in the area, and we have had complaints from residents about adjacent residential premises, noise from patrons outside, noise from doors and windows being open, noise from various sorts of entertainment activities. But it is fair to say that the licensing conditions relating to the majority of the licensed premises in the area are sufficient in sort of dealing with the problem. So if we do receive complaints, licensing or our team sort of go out and speak to the licensee. Just looking at one I've got here, in relation to a licensed premises complaint in 2017, 2018, noise from sort of customers outside, and music, entertainment activities and so on in the area.
Okay, I think we get. Yeah, I just wanted to distinguish those complaints as against specific complaints, obviously. Councillor Brotherton or any of the panel members, do they have any other questions?
I have a question, Councillor.
Sorry. Oh, Joanne.
Yeah, could I just ask Nazreen?
Yeah.
The application also includes the use of the outside area to the rear of the property.
Yes.
Would that have an impact on residents at the rear of the property if the license, people were allowed to sit outside and drink until midnight?
Well, I've agreed with Felicity a condition which restricts the use of the external area to the rear until 9 o'clock. I think so. After 9 p.m, there should be nobody in that external area. So so that protects residents to the rear. Equally to the front, there is an external area, and we've both agreed a condition restricting the use until 11 o'clock. I think nobody should. So there are controls in place, and we're not, personally, not against the premises or licensed premises in the area, but what is important is all, or the majority, I think 99% of the licensed premises in Altrincham Town Centre, and in particular in this area, are located on the ground floor, whereas this is on the first floor. And from a planning point of view, I received numerous planning applications, and you're meticulously going through planning applications to ensure that occupants are not negatively impacted by noise from commercial uses. So a few weeks ago, I dealt with an application for an office next door to a residential property, and you really have to sort of make sure there's appropriate noise mitigation, appropriate glazing, acoustic ventilation, etc., to protect the occupants. And what we've got here is a scenario where you've got entertainment activity taking place on the other side of the party wall of noise sensitive premises, and the absence of any planning control, it makes it more important for us to ensure that the sort of public nuisance is prevented from this activity. And it's live music, recorded music, playing of films. I've had complaints in Altrincham of restaurants where there's just recorded background music, but just the sheer number of sort of customers, and when I say sheer number, 20, 30 customers at one time on the other side of the party wall, it's inevitable that there's going to be noise and disturbance, and add to that regulated entertainment. Sorry, go on, Felicity.
Sorry, Chair, may I ask a couple of questions of Nazreen?
So it's your turn now. It's your turn to ask some questions of the representative.
Thank you. Just one or two. Obviously, we're not talking about other licensed premises in the area. We're talking about the application for this one. Have you had any complaints relating to Common Ground as it trades currently?
As it trades, my understanding is Common Ground have had this licence since about 2017, and there's been appropriate conditions on the licence to contain noise only on the ground floor, because on both sides you've got commercial premises. So on the right to Common Ground you've got a commercial property, onto the left you have a commercial property, and there's been conditions to contain the noise, because the time that the noise would be particularly disturbing to residents or anybody would be sort of later on in the evening.
Nazreen, sorry. So no, is the answer no? There'd be no complaints in relation to the way in which Damien has been operating thus far?
No, not on the ground floor, no.
Okay. And I just wanted to ask you about safeguards, because what I'm struggling to understand is that you say that some conditions are appropriate and offer those safeguards. So, for example, the condition relating to the use of the space outside to the rear prevents its use post 9 p.m, and a condition to the front restricts its use post 11 p.m. Those conditions seem to be satisfying you, in that you're confident that Damien will adhere to those, and if he does, then noise issues won't arise. But I don't know why, I'm struggling to understand why you believe some conditions will help, but then others don't. You recommended a condition, PPN 3, in your representation, which we've agreed.
Yeah.
And if that is adhered to, surely it must therefore follow that a nuisance will not be caused.
Right, so I don't have any issues with Damien or his capability to control noise from the premises. So I don't have an issue with that. My issue is with the actual facts of the situation, and the facts are that you have a building, basically you've got a party wall, and on the other side of the party wall you have a noise sensor. You've got 2 bedrooms, and you also have a lounge, and noise from the entertainment activities is going to be audible. It's going to be a problem to residents.
Why will it? The condition specifically says that any noise emanating from the premises shall be inaudible, so as not to cause a nuisance. So I'm struggling to understand why you think that it's inevitable that an issue will occur if we've got a legally binding requirement to make sure that it doesn't.
Yeah. I can only speak from personal experience. So I do not, experience dealing with other premises in the area. You've got here a licensed property that's structurally attached to a residential property. Entertainment noise, especially at low frequencies, it can readily transmit through the structure of a building and be clearly audible within habitable rooms of these dwellings. So I don't see, there may be a condition there to protect that, but whether the structure of the building allows Damien to do that is another issue altogether.
But if the imposition of that condition on the licence will make sure that he has to do whatever it takes to make it inaudible. So whatever it takes, otherwise he'll be guilty of a criminal offence.
Sorry, I don't understand.
So you said that you fear that the structure of the building might give rise to a nuisance, but we have agreed a condition that you've suggested that means that Damien he'll have a legal requirement to do whatever it takes to make sure that that condition isn't breached. So if there are, and I'm not saying that there are, but if there are structural defects in that wall, he'll have to remedy them.
I'm looking at the application as it is, and there's nothing that you've put forward to me to say that any measures are going to be sort of acceptable to do that.
No, but we've agreed the condition that you've requested. I think perhaps
I'm assessing the application. I'm assessing the application. Obviously, Damien is a licensee. I'm looking at the application premises and the potential for impact to the residential properties, and I don't have information in front of me to say that the neighbours are not going to be impacted negatively, and experience of dealing with other premises in the area where the licence has been granted for a licensed venue adjacent to residential. We're dealing with noise nuisance cases. There's clearly problems. Residents are being affected by the noise from the property, irrespective of imposition of conditions, because of the structure of the building. That's something that I can't control. Damien can't control. He can put measures in place, but in my opinion, it's inevitable that noise is going to be audible in the neighbouring residential property.
I don't have any further questions, but obviously we'll sum up in due course. Thank you, Chair.
Okay, I think actually, unless there's any questions for the environmental health or any further questions, I think we'll move to the summing up, which Nazreen is environmental health, the representative. Would you like to start with summing up? Your summing up, please.
Yeah, basically, I mean, just really, I appreciate the position of the applicant, and it's important to highlight that the area is a mixed area. It's not wholly commercial with licensed premises. There are a number of residential premises in the vicinity. This residential property has been permitted to be there prior to any application made by the applicant, and it's important for the occupants to be protected from any public nuisance that is likely to arise as a result of entertainment noise up until 12 o'clock, 12:30 every day of the night, and those residents don't have control of walking away from. Okay, they have a choice to live in the town centre, but they do not have control of being able to switch off entertainment noise at a certain time. That's going to go on until 12:30. So I just recommend that the councillors take that into consideration. And it's also important to note that other licensed premises in the area are really on the ground floor, as opposed to sort of first, second floors adjacent to residential premises. Thank you.
Thank you, Nasreen. Ms. Tulloch, do you want to sum up for the applicant, please?
Yes, thank you, Chair. Yeah, I just want to sort of bring it back to the facts of the application and what we do know about it. There's been a lot of speculation about what might happen in the future, but before you is an application for a premises licence until midnight plus 30 minutes daily on the ground first and second floors. With a set of conditions which we formulated as part of an operating schedule and which has been further enhanced by the agreement to additional conditions as proposed by Nasreen. It is a predominantly commercial area. There are some residents nearby, but the majority of the use in the area is commercial. There has been one objection from Nasreen, nothing from the police, nothing from the licensing authority itself, nothing from any of the other responsible authorities, and no objections from the resident. Much concern is being given to the landlord of the adjacent flats, but he was perfectly able to lodge an objection during the consultation process, but didn't. And we don't know if those that flat that has the party wall will be developed. We don't know if it is, when it will be. We don't know who may or may not choose to live there, and it would be a choice. And as Councillor Butt identified earlier, that person would take that flat knowing the area within which it was situated. We don't believe that noise nuisance emanating from the premises is inevitable at all. Far from it. Damien is an experienced licensee. You've heard that he has been running his existing premises, which benefits from a licence, without any issues whatsoever. There's no evidence to suggest that if he were allowed to move into the upper floors, that a nuisance would occur. You've heard that the capacity, even post-COVID, is not large, particularly on the second floor. It may be, Chair, that the use of the second floor, in your opinion, you asked some questions relating to it, might not be, in your view, suitable for the playing of live and recorded music up there, but due to its size. But it's certainly Damien's wish to be able to provide it on the ground and the first floor. So we'd ask that the licence is granted in its amended form, and that is with the reduced hours, which was offered some time ago to Nasreen, together with the conditions which he's asked that be attached to it, because there are the safeguards in place. If, and Damien is absolutely confident it will never arise, but if there should be an issue going forward, there are numerous ways in which he can be taken to task or situations can be addressed. And so a balance, in my view, needs to be struck between allowing Damien to develop his business in what is a very challenging time against the needs of future residents. And I'm not saying for 1 second that they mustn't be considered, but we need to strike a balance, in my view. And that balance, I think, is met with the reduced hours and the imposition of the conditions which we've talked about. So I'd ask you, in the strongest possible terms, to grant the licence. Thank you.
Thank you, Mr. Tulloch. Can I just ask the legal officer to summarise, please, for the committee before we retire to make our verdict?
I don't think I've got anything to add at this stage other than what's already been said, but obviously I'll retire with you all, and if you have any questions I can answer them then.
Right, are we going to notify all parties in writing, or are we going to notify them? Yeah. So they needn't actually stay on the call really then.
That's a matter for you, Chair. I believe you can come back into the meeting after we've made a decision, but they will subsequently have a decision in writing anyway.
Right. Okay. Well, I'd prefer to do that. I mean, it's up to them if they wish to hang on. We don't know how long we're going to be deliberating. Really, it's quite a lot of issues to go through, to be honest. Okay. So I think we'll ask our administrator to put us into the closed session, if that's okay. Is he there?
Okay. Yes, I've just Councillor, are you okay for me to start the live recording again?
Yeah, sure, yeah. Let me know when I can start.
We're now live.
Okay, thank you everyone for your forbearance. Okay, so we've carefully considered what all parties have said. The decision is that we're going to allow the licence application for the ground floor only for the hours applied with the conditions agreed with the Environmental Health Officer. We're not going to allow the application for the first and second floor for the reasons of public nuisance. Specifically, we're not satisfied that the partition walls would contain noise nuisance and low-level vibration emanating into the neighbouring residential properties, even with the conditions outlined. So, thank you for your attendance. And thank you for your input into the meeting, which was conducted in good spirit. I'm sorry it's not the outcome the applicant wanted, but nevertheless that's the decision of the panel. And you will be receiving a written decision which will be sent to the applicant shortly. And obviously you have the right of appeal, which will be outlined in the letter. Okay, so unless anybody's got any final comments, I think that concludes the meeting, and I think I'll close the meeting and thank everybody for their attendance and their input into the meeting.
Thank you.
Chair.
Thanks everyone. Cheers.